Okay, welcome and thank you for all that we're waiting in the waiting room and for your patience. SEIU Local 1, we're so excited to be here again. Today, for our legal services introduction, we are talking about bankruptcy. Just so you know, a few logistics. This presentation is being recorded. All members will be on mute and off video, but if you have a question, go ahead and drop it in the chat, and we'll address that at the end of the presentation if we have time, and if not, we're happy to follow up with a phone call as well. One clarification that I want to give before we get started. So earlier this week, we heard about immigration law, real estate, and estate planning. Some of those legal services or the legal services under those types of law are currently covered by the fund. However, because we are a new fund, we are not right now able to cover bankruptcy fees. That being said, our members have requested information and support. And so today we have our attorney of the day who is going to give us information about bankruptcy. And we have a list of referrals that you can access if you're interested or you need these services. So without further ado, I would like to introduce you to Salvador Lopez. Attorney Lopez or Salvador has been practicing since 2008, opened his own firm in 2012, and really focuses on not just providing great legal service, but also legal education. He's worked a lot with the community members, with various nonprofit organizations, and additionally his own private clients in bankruptcy and a variety of other types of law. So I turn it over now to Salvador to tell us about bankruptcy. Thanks.
Yes, good afternoon, everyone, and happy Friday. Thank you for allowing me to present to you on this topic. And as Ellen said, bankruptcy law is my area of practice. I would say my area of expertise at this point. I've been practicing almost 2 decades. And that entire time has been in consumer law, of which bankruptcy is a part of. So I'm going to dive right in because I know we're limited on time. Let me just go ahead and do a screen share and start with the slides. And Ellen, can you confirm that you are able to see the slides?
Definitely see the slides. You're doing good. Thank you.
All right, okay. All right, so bankruptcy, it's what I like to refer to as the sledgehammer in your toolbox of consumer rights, right? You can defend a collection lawsuit, you can negotiate with creditors, there's modifications with foreclosures, there's renegotiation, there's refinance. There's a lot of options when you're a consumer who's dealing with financial issues, but bankruptcy is sort of the sledgehammer you bring out for the big jobs, right? It shouldn't be taken lightly. From one perspective, it shouldn't be taken lightly, but from another perspective, it's a very powerful tool that you should always keep in mind. So just quickly, we're going to do, and I think Ellen already covered this, we're just going to do it what, who, why, when, where. It's typically the fastest way to get through a topic. So what is bankruptcy? The central premise of U.S. bankruptcy law is that it's for the honest but unfortunate debtor. That's a quote from a U.S. Supreme Court case from about 80 years ago. It's an organized, realistic, and fair method for dealing with a very difficult time in most people's lives, right? And this third bullet point is the main thing, is it puts the debtor back in control. If you are experiencing a financial hardship, financial difficulty, we'll get into the different types of hardships and difficulties that people face, but essentially people feel powerless when they're in that circumstance, right? Not having enough money or facing unexpected expenses can put you in a situation where you just don't know what to do. And you get phone calls, people are telling you what to do, you ask for help, and maybe the creditor is not willing, or maybe they say they can't. You feel helpless. Bankruptcy allows you to get back into the driver's seat with limitations, right? It obviously can't accomplish everything, but it at least allows you to slow things down, figure out what your rights are and what you want to do without being forced to. It immediately stops all collection activity, whether that's foreclosure, collection suit, or wage garnishment, license suspension, utility shutoff, anything that a creditor is trying to do to get you to pay or to recover their funds through the administrative or court process, filing a bankruptcy will immediately put a stop to that. That's called the automatic stay. Stay as an activity stayed, meaning that it's frozen. And once you file a bankruptcy, if the creditor wants to continue collection activity, they then have to go into the bankruptcy court case and ask the judge for permission, which takes time. And a lot of times, just because they want to move forward doesn't mean that they will be allowed to. And this last bullet point, bankruptcy provides an option for reorganization. Right, I get into a little more detail, but most people, when they think about bankruptcy, they think of like, oh, I don't have enough money. I want all my debts erased and start all over. That's direct bankruptcy. I do a lot less of that type of case. What I do more is Chapter 13, which is reorganizations where you just, people say, I can afford my current debts. I just can't catch up on everything that I'm behind. I just need a little bit more time. And that's what bankruptcy allows you to do, to slow things down, get more time, and get things back into control so you can move on with your life. Um, Most people say, the unfortunately, the bank and credit card industry has done a pretty good job of making bankruptcy into a bad word, right? There's a stigma and embarrassment surrounding it where people think, oh, I don't want to file bankruptcy. I'm embarrassed. I can't afford my bills. And people say, oh, they're going to think I'm an irresponsible, a consumer, that I just spend too much money and that I have no self-control. And that's in my almost 20 years of practice, I have still to meet that consumer who comes through my door and has to file because they were irresponsible. Most people who have to file bankruptcy is one of these things caused them to be in a financial hardship, whether it's divorce, right? Half of your income is gone. An accident, whether that's work, car, or other type of accident, an unforeseen illness or hospitalization, even a week or two off of work can wreak havoc on people's finances. Medical bills, even with insurance. I've seen people with tens of thousands of medical bills that they can't afford. That's part of what they're supposed to pay. Job loss or reduction in income, obviously. Unexpected expenses. People don't account for that. If you, a common example is if you have you're making enough money, you're paying your bills, things are going okay. You have a nice, reliable car that you have an affordable payment. You get into a car accident. Obviously, it's not your fault that you got into a car accident. It's an accident. Your insurance company either pays off the car and doesn't give you anything or gives you very little. Now you have to buy a new car, and with interest rates so high, you have to come up with a down payment and a high car payment. That could destroy people's finances from one day to the next. Or if your furnace goes out in the middle of the winter where we live, are you just gonna not replace your furnace? No, you have to. And the $3,000 to $5,000 it's going to cost you to replace your furnace is going to force you to either stop paying other things or take out a credit card, which is then going to increase your monthly expenses. What is bankruptcy not? Bankruptcy is not punishment. It's not punishment for the consumer, for the debtor, and it's not punishment for the creditor. It's a set of rules that determine what will happen with your finances and who will get what. It's also not open to abuse, right? The whenever a bankruptcy case is filed, doesn't matter what's chapter 7, chapter 13, 11, 12, or 15, there is a trustee assigned, and that trustee typically works for the United States trustee. The United States trustee is part of the Department of Justice, the same Department of Justice with the FBI. So bankruptcy is not open to abuse, and there are criminal cases that are brought. You hear about it in the news every once in a while of people who try to lie on their bankruptcy petition. It's also not unrealistic or unfair. There's limitations to what bankruptcy can do. If it's going to take $5,000 in disposable income a month to accomplish your goals, and you've only got $1,000 in disposable income a month, bankruptcy is probably not going to be your solution, at least not in Chapter 13. It's also not magic. And I use this because in reference to people just waiting too long to use bankruptcy as an option. I've met with people who I've advised to file Chapter 13 to save a house or save a car, and they decide not to do it in the moment, which is fine. But then I get a phone call 2 days after a house has been sold saying, okay, I want to file bankruptcy now to save my house. And it's too late. It's not magic. You can't use, I can't wave a magic wand and reverse time. There are some limitations as to when you have to file bankruptcy. So just the sooner you get advice on what bankruptcy can accomplish for you and what your timelines are, the better. That way you don't miss out on potentially saving whatever it is that you're trying to save. And some common myths that I like to go over is that people think bankruptcy is private. It's not. It's a public record, right? It's a court case, a federal court case, and all court cases are public record. I get the, oh, bankruptcy is easy. You just fill out paperwork. It's not. It's a very rigid court process with hundreds, sometimes thousands of pages of documents that have to be filed in court. The another one is, okay, I'm ready to file bankruptcy. Let's file tomorrow, and then we'll start working on my case. That's not how bankruptcy works. That's, a typical lawsuit is, oh, we file a lawsuit, and then there's months of discovery, depositions, court dates, and then you get to a trial. Bankruptcy is the opposite. A majority of work is done before you file the case. You actually have to prep the case. It could take weeks or months to have everything ready to go. Then you file the case, and then most of the time period after the case is just allowing the court and the trustee to review the paperwork, and have a couple court dates. And if it's Chapter 13, confirm the plan and start taking payments. Chapter 7 is ensure that there are no assets and just wait the time period for the debtor to receive the discharge. Another one, unfortunately, people think of, oh, it's bankruptcy. It must be free or cheap. Fortunately, it's not. It varies across the country, but I can tell you in the Chicagoland area, you're looking at anywhere from $2,500 up to $6,000 in bankruptcy costs and attorney's fees, which is the old saying. A lot of lawyers joke is that sometimes you're too poor to even go broke, which means you don't have enough money to file bankruptcy. Another myth: oh, I'm going to lose everything if I file bankruptcy. That's not true. I can tell you it's extremely rare. People who lose something in bankruptcy, it's because it was either part of the plan. Someone says, I can't afford this car, I just want to turn it back to the creditor, or they lied about something. If you lie about an asset and you file a bankruptcy, there's a good chance that you're going to lose that asset. Another reason to not lie. Another myth: you will be able to keep everything and not have to pay. People think, oh, just, I'm going to take out all these debts, buy all these cars, and, get another house, and I'm just going to file bankruptcy. Like, you can file bankruptcy, but you're probably going to lose those things. If it's secured debt, you still have to pay back the money on that debt, or you won't be able to keep it. Um, the myth that bankruptcy will destroy your credit for 10 years. This is the one that bugs me the most, because people think, oh, I can't file bankruptcy, my credit is going to be ruined. I tell people, I'm like, you haven't made a mortgage payment in 2 years. You're behind on 3 credit cards, right? You're being sued by 4 debt collectors. Your credit's already ruined. And every month going forward that you don't pay and that you continue to get sued, your credit's going down further and further and further. Alternatively, if you file a bankruptcy, it puts a freeze on everything. And assuming your bankruptcy is successful, which typically when you file like I said, since it's front loaded, by the time we file the bankruptcy, we already know that it's going to be successful. That means that from the day that you file the bankruptcy, yes, your credit score is going to take another tumble, but then that's it. Every month after the fact, there isn't another hit to your credit saying that you're not making payments anymore. You get that fresh start and you get to climb out. It's very common it's not quick, right? It's not months. But it's very common for people a year and a half, 2 years out of bankruptcy to see significant improvement in their credit as long as they take responsible steps. And so there's different types of bankruptcies. There's Chapter 7, 11, 12, 13, and 15. The ones that are consumer bankruptcies are Chapter 7 and 13. 11 is for corporations, 12 is for farms, and 15 is for municipalities, counties, and cities. But as I said, consumer bankruptcy is typically Chapter 7 and Chapter 13. And Chapter 7 is what most people think about when they think about bankruptcy. It's called direct bankruptcy, where you're just filing a case and asking for your debts to be discharged. Discharge is a technical term, which basically just means erased or forgiven by the court, meaning that they can no longer be collected. Chapter 13 is a reorganization. You can also receive a discharge in Chapter 13. Most people commonly do, but it comes after a time period where you make plan payments for 3 to 5 years. Most of the time when I file Chapter 13, it's because we're trying to accomplish something. We're saving a house, we're saving a car, we're ensuring someone keeps their driver's license in order to be able to continue to work, or in circumstances when people make too much money for their household size to be able to qualify under the means test for Chapter 7, they have to file Chapter 13, which basically says, well, you can still receive a discharge, but you're going to have to pay some money for a period of 3 to 5 years. Now, this is a little hyper technical, but most of the time when we're talking about bankruptcy, there's just different types of creditors, and different creditors receive different treatment under bankruptcy law. There's priority creditors. A priority creditor receives a different or special type of treatment by law, and we're talking taxes, child support, alimony, where the law says that this type of debt receives special treatment. And then the secured creditors who receive a different or special type of treatment based on an agreement, right? If you sign a mortgage, you're agreeing that that creditor has a security interest on your home, so they receive special treatment in bankruptcy. Similar with a car, right? If you take out a car note and you're pledging the car as collateral, then that creditor has to have basically first dibs on the money, so you can make sure that you can keep your car if you're intending to keep it. If you're surrendering it, then they're treated just like an unsecured creditor, which is a third type, which is every other type of debt: credit cards, medical bills, payday loans, personal loans. If there's no security or any protection provided by law, it's considered an unsecured debt. So Chapter 7, the bank basics. You put together a petition, which is, like I said, hundreds, sometimes thousands of pages of documents where you list everything, all of you're an open book, all of your income, all of your assets, all of your debts. I mentioned contingent income because hey, you also have to say if you're going to inherit $1 million next week, you have to tell the bankruptcy court about that. If you're going to have a bonus of $50,000, in a few months, you have to tell the bankruptcy court about that. If you've got a winning lottery ticket at home, I've actually had a client who had a $10,000 winning lottery ticket. You had to tell the bankruptcy court about that. So you disclose everything to the bankruptcy court. A Chapter 7 trustee is assigned. If there are any assets that are not exempt means that they're protected. If you have a car that's worth too much money, if you have too much equity in your house, if you've got too much money in the bank, the trustee would typically take that, cash it, sell it, whatever, distribute. But like I said, 99.999% of the time, the trustee takes nothing, because by the time we file the case, we already know that there are no exempt assets. And the only time that they do have to administer, which means take something and sell it, is when we're planning it, when we say we're surrendering this piece of property because the consumer, the debtor, no longer wants it or can't afford it. Or if it's a broken down car, right? If you have a car that's got a blown out engine and you owe $30,000 on it, we can say we're surrendering this car. The debtor no longer wants it because they don't have the $20,000 to replace the engine, and it's also not worth the $30,000. But what typically happens instead is after the trustee reviews all the paperwork, they will file a report of no assets, meaning there's this debtor, not that you don't have anything, it's that you don't have anything that the court can take because the law protects everything that you have, or because what you have has no equity, right? If you've got a house that's worth $300,000, but you've got a mortgage on it for $280,000, after expenses of selling the house, you don't have a house, right? As my clients say, the bank has the house, right? And there's no, once you file the bankruptcy, it's a snapshot. It takes a look at that period in time. It's not looking at, well, your house is worth $300,000. You're probably going to have money in the future. It's not. It's what is the circumstances right now and what we know is going to happen. Like, expected changes. Like I said, if you've got that inheritance coming in, that snapshot includes your knowledge that inheritance is coming in. So after the trustee would file the report of no assets, then and there is a meeting with the trustee that you would have to go to, where you're put under oath and to make sure that you answer all the questions, saying that you didn't withhold anything or any information. Process for Chapter 7 after you file a case, right? Because remember, it takes weeks or months to prepare the petition in advance, to put the case before we actually file it. But once it's actually filed, it's about 3 to 4 months for the discharge to come in, for your debts to be erased, and for your fresh start to begin. One important thing: a Chapter 7 cannot be voluntarily dismissed. And I mentioned this because, as a bankruptcy attorney, one of the common advice situations where I give advice is I tell someone, do not file a Chapter 7 bankruptcy. And that's typically, it winds up being most of the time senior citizens who own a home free and clear or have significant equity in the home. Unfortunately, we're going to talk a little bit further down about what you can protect in a home. It's currently $15,000. It's going to set to increase to $50,000 or $100,000 as of January 1st if you're a married couple. But if you've got a house that's worth $300,000 and you don't owe anything on it, and you've only got $30,000 in debt to credit cards, do not file a Chapter 7, because there a trustee can come in and take your house, and you can no longer say, oh no, never mind, I want to dismiss my case. The trustee's going to say, too bad, so sad, too late, we're going to take your house. I get that phone call often, well, somewhat often. If I get 1, 2 a year, it's too many times in my opinion. But I get that phone call where someone says, I'm about to lose my house, I have to come in on an emergency basis, and then we wind up having your only option at that point is to convert the bankruptcy case into a Chapter 13, where you now have to pay typically the full value of that unsecured debt over that time period of 3 to 5 years. So one of the reasons you want to consult with an attorney is there are circumstances where you absolutely 100% should not be filing bankruptcy for any circumstances. And it's usually related to a house, or if you got a ton of money in the bank. Okay.
Hey, Sal, I'm going
Yes.
to interrupt for 1 second because I forgot to make the announcement that there is
Sure.
interpretation available. And so if
Ah,
people are online and they go down to the globe, there's a little icon, there's a globe. You can get into Polish or Spanish. And then I'll also just give the reminder we have about 10 minutes left. Um,
okay.
so we have about 10 minutes for the presentation. Thank you.
Okay. Chapter 7 basics, mostly people who have unsecured debt, you don't have non-exempt assets, which means you're not going to lose anything, and that you're not behind on debt secured by collateral. You're not behind on your rent, you're not behind on the mortgage, or not significantly behind at least. There's enough to cure, or on your car. It's the best time to consider Chapter 7, as I tell people, is when you can see the light at the end of the tunnel, not when you've hit rock bottom, but when you're like, okay, I now am back on my feet. The temporary issue that I had with job loss, or with a medical issue, with unexpected expenses, that's been resolved now. I can afford my current monthly expenses. I just can't afford everything I'm behind on. That's typically the best time. When you say, well, I can't afford anything and I'm just going to continue going downhill, I still don't have a job. I tell people don't file yet, because it could be, it could be another few months, hopefully not, but it could be weeks, months, years before you get another job where you're able to get back on your feet. And what happens if you get into a car accident the next day, or you fall down some stairs and break your leg? Now you're going to have medical bills after you filed bankruptcy, and you can't retroactively add to the bankruptcy. It's a snapshot at the moment that you file the case. So just timing is very important, is what the message that you should take away from that. Okay, Chapter 13 is the basics are all the same. You file as a Chapter 7, you file a petition for relief where you are an open book, all of your assets, all of your income, and all of your debts. The difference here is that most people think that when you file bankruptcy, the court will tell you what you have to pay, and they don't. Bankruptcy has a list of rules. It's sort of like a formula that says this has to be paid in this way and this method. And as long as you're following the rules, you propose to the court a plan where you paying back. You say, I'm going to pay back 100% of my mortgage arrears. I'm behind $20,000 on my mortgage. I'm behind $3,000 on my car. That's all going to get paid back. I'm behind $4,000 to the IRS. That's all going to get paid back. And then I've got $10,000 in unsecured credit card debt, and I'm going to pay 20% of that. I'm going to pay them $2,000. And that meets all the rules. That meets the formula that's prescribed by the bankruptcy rules. The trustee and the court review that and they say, okay, your plan is confirmed, which is the step that the judge has to take. And then once the plan is confirmed, all you have to do is make the payments under that plan. And then at the end of the plan, you receive the discharge of that remaining unsecured debt, the $8,000 in that example I gave, and you move on with your life with your fresh start. It gives you an opportunity, like I said, to cure arrearages. The discharge does not come until the plan is complete. And it does provide what's called a super discharge. The most common example I'll give is parking tickets. If you file Chapter 7, the rules say that parking tickets are not discharged. You coming out of the bankruptcy, you will still owe those parking tickets. However, in a Chapter 13, if parking tickets were part of that $10,000 example I gave, and you're only paying 20% to those unsecured creditors, as long as the parking tickets get their 20%, at the end, those parking tickets are also discharged in Chapter 13. So there are some benefits to 13 versus a 7. So why might you need to file bankruptcy? Common examples, calls, letters from creditors, and I know how aggravating it can be for the phone to just stop ringing with collection calls. You're being sued. There's a foreclosure. Your car's been evicted. Your car's been impounded. You have an impending eviction. Your utilities, your gas, your electricity are shut off. Your car is either repossessed or about to be repossessed. This is the most common where I tell people, keep in mind, you don't want to consider bankruptcy only after something has happened. You want to plan when you say, okay, I've only got a few more months that I can make my mortgage payment, and then I'm going to run out of savings, and then I'm going to plan. That's at the time that you should consult with a bankruptcy attorney. When you say, well, I can still make the minimum payments on my credit cards, I should be okay. But the minimum payment on your credit cards usually doesn't even cover the interest, which means that the amount is going up, up, up. And if your unpaid balance is going up, that means that your minimum payment is also going up. And just because you can cover it now means that does not mean that you'll be able to cover it into the future. That's at the point that you should be consulting with an attorney about potentially considering bankruptcy. I'll quickly touch on collection proof. Some people call it judgment proof. I do not like to say judgment proof because no one is judgment proof. No matter what you have or don't have, you can always be taken to court, and you can't be punished. You can't be put in jail. You can't. The judge cannot impose any kind of punishment on you for not paying your debts as long as they're consumer debts and you just don't have the money. But you can get taken to court where they can get a judgment against you. But that judgment still has to be enforced, and that's why I like to say collection proof. If you are, and it's mostly typically senior citizens, if you have limited income, no real property, no house, right? That's home free and clear. You don't have significant, you can have significant savings as long as it's based on one of the protected income sources of income, like Social Security and employment, disability or pensions, and your situation's unlikely to change. Your collection proof, right? They can get the judgment against you, they can call you, but as long as you don't make voluntarily payments, they can't force you to pay anything because the law protects everything that you have. And I will clarify, Social Security, unemployment, disability, and pension is fully protected by state and federal law, which means it cannot be garnished. You could have, $100,000 in the bank. As long as you can prove that that's all Social Security or pension, it cannot be garnished. There's also exemptions. The exemptions are the things that the law allows you to keep. Currently, the exemptions in Illinois, if you have a house, you can have $15,000 of equity if you're single, or $30,000 if you're married and both file bankruptcy. That's a pittance, in my opinion. Luckily, it's going up as of January 1st. That will be $50,000 and $100,000 if you're married. Um, but remember, just because it's an asset that's protected right now, if you're continuing to pay the mortgage, and 3 years from now you decide, okay, maybe I should consider bankruptcy now, and at that point, because the house has gone up in value and you've paid that more, now you've got $200,000 in equity, bankruptcy may not be a solution for you anymore. You're currently allowed to protect $4,000 in wild card, which means anything, any property, and that's usually just for cash typically. Vehicle, $2,400 in equity, it's set to increase to $3,600. And tools of the trade, if you work in an industry where you're required to have tools, $1,500, and set to go up to $2,250. There's also protections by law of when your wages cannot be garnished. Those are what it currently at. It increases incrementally every year because it's based on minimum wage laws. But currently, if you don't net at least $675 a week, $1,250 biweekly, or $2,925 if you're paid monthly, then you cannot be garnished. If you make more than that, then you garnish either the amount over or 15%, whichever of those two amounts greater. Okay, when you should file. Do I need
Sal, sorry,
to?
one more interruption. So much great information. I think it's wonderful. For timing, could you just maybe summarize these next three when slides? And then
Yes.
if our members have questions, I'm happy to have them reach out to you for a direct
Now,
consultation. So you can just kind of summarize these when and what people should determine.
yes. And I mean, the simplest way, yeah, I can get through this quickly. When do I need to accomplish something through bank? Do I need to accomplish something through bankruptcy? If you're facing any kind of financial difficulty, no matter how small it is, consult with an attorney, right? There's no time that's too early. There are a lot of times when it's too late. So if you're feeling any kind of financial stress or you know that it's coming down the line, just consult with an attorney. Um, is the timing right? Timing is very important, and the sooner that you can consult with an attorney, the better. I mean, obviously, if you're already facing foreclosure or cars being repossessed or impounded, those are obvious symptoms that you probably should consider bankruptcy, but the sooner the better. Um, there are circumstances where you cannot file bankruptcy if you've had a bankruptcy within a past certain amount of time. If you don't have enough income to support a Chapter 13, do you have something that you will lose like a house and you should not be filing Chapter 7? These are all questions an attorney can help you figure out. You should call an experienced bankruptcy attorney. Be cautious. There are petition preparers out there, which is people that are allowed to help you fill out paperwork. They're not attorneys. They're allowed to give you legal advice. I also tell you, I get phone calls pretty often where people say, I need a new attorney. My current bankruptcy attorney is saying they can't represent me anymore, and I'm having this issue. Come to find out that it was, an attorney who does criminal defense and divorce. And nothing against my colleagues, but bankruptcy is a complex area of law, and there are some complicated cases that should be filed by experts in the area. And I wind up having to take over cases pretty often because it was filed by someone with insufficient experience. Be realistic with yourself financially, right? I tell people that all the time. Bankruptcy is federal court. I added there is a pro se advice help desk that's run by the Chicago Bar Foundation where you can call for advice. They only take about 8 to 10 people per day, and it's by phone. You're limited to 20 minutes, and it's only advice. They do not represent you. Um, Let me see. There was one other thing. The two important tips that I want to tell people all the time: debt consolidation companies are scam 99.9% of the time. There are some like the Center for Economic Progress, which I think they've changed their name to Ladder Up recently, that are not for profits that help people, but usually they tell people that consolidation is not going to happen for you. It's not an option for you. Most of the time when people are facing financial difficulty, these companies prey on them and say, oh, just give us $500 a month and we'll deal with it. But what they're not telling you is that of that 500, 375 or 400 is their monthly fee. And then the rest of it is that the money that they're trying to use to negotiate with your creditors. After a couple of years, you start to get sued and everything, the house of cards falls and they don't give you your money back. Credit repair companies are always a scam. There is no such thing as credit repair when the reporting is accurate. So just be very cautious that a lot of my clients get taken advantage of in those circumstances. And I think, Ellen, this is yours.
Yeah, so that was a wild round of bankruptcy. Thank you. I think I learned everything. I learned something new every time we have one of these presentations. And Salvador, thank you for sharing what I've learned on this presentation. Some of the big takeaways I have is that there's different types of bankruptcy. And if you find yourself in financial trouble, you can reach out and talk to an attorney and get a consultation about the best way to move forward. And that bankruptcy is really kind of a really big process that could have an impact in the short term and the long term. But hopefully people are also considering other processes and consulting with people that can give them good advice.
Yes.
So yeah. So what I'm happy to say then is that the Training and Legal Fund is able to connect you with attorneys, with bankruptcy attorneys, and people that have experience in financial issues and counseling people who work like SEIU Local 1 members and can counsel you on what to do with your hard-earned money and some of the issues you might encounter. So while right now we're not able to pay those attorney fees, I know that there are many services that offer free consultations or just to get you pointed into the right direction. You can call the Legal Fund at 312 233 8794. Again, that's 312 233 8794 to get connected with some wonderful attorneys like Salvador today. So I want to thank our interpreters. Thank you for this presentation. Thank you for all of you that attended this week. We're excited to interact with you and engage with you and make sure you have access to your rights. So thank you and have a great rest of your week.